So thank you for joining the Doughty Street immigration team for our last webinar of 2020. A year in which we've all had to face, at the very least, uncertainty and challenges that seemed unimaginable just 12 months ago. It seems fitting then that we end this year with a seminar on probably what is the only other topic that could rival the pandemic in terms of uncertainty, change and challenge. Our three expert speakers today will discuss the new legal frameworks in place for around 45 minutes, which should leave 10 to 15 minutes for questions. I'm aware not everyone is yet in the webinar, but I'll keep on speaking in the introduction, and hopefully by the time the speakers start, everyone will have joined. So in terms of questions, I know that several people have emailed in questions already. Otherwise, if you can use the question and answer function to ask your questions, we will then try and answer as many of those as possible at the end. There's also a chat function. If you can keep your questions to the Q&A, but feel free, if anyone has any comments or anything else, or has any answers themselves to any questions, then feel free to use that for chat amongst attendees. We may not, though, be able to answer that ourselves. So in terms of content today, we'll first be looking at the situation for EEA nationals and their family members who are already well established in the UK. And John Walsh will kick us off by looking at exclusion, including deportation and suitability criteria and appeal regimes for those people. Krishnendu Mukherjee will then look at the transitional arrangements for people already in the country. And our final speaker, Simon Cox, will look at the position for EEA nationals and their family members who are not yet in the UK or who are just arriving. So without further ado, I'll hand over to John, who will start with exclusion and deportation.
Good evening, everyone. You see the three topics up there in the screen, and as outlined by Rowena. I will change the order slightly in that I will do appeals after exclusions and leave suitability until the last of the three topics. Next slide, please. Now, I've sort of put in a modest aim there of the session, so that at least at the end of the session you'll know where to find the answers if you don't find the answers today, but at least you'll it's a very tricky subject matter we're dealing with today, and it is not easy to identify at what stage certain things are happening, but I think at the end of this session, indeed, into my session, you will know where to look for the answers and what is the relevant regulations in particular that you need to be aware of. Next session, please, or next slide. Thank you. Now, the firm ground was, as you know, about in the context of deportation and all that, is we had people who are subject to immigration control and people who are not subject to immigration control. EEA nationals were not subject to immigration control. Instead, you looked to, we had the UK Borders Act, of course, which you had automatic deportation provision. That didn't apply, was never applied to EEA nationals. And that was, you'll know, the system there was for if you have to reach the threshold of 12 months sentence, you'd be automatic deport. But for EEA nationals, we look and have been looking for many years now, back since 2004, at what were then the EEA regulations 2004 and the directive 2004. I think the regulations were 2006, and now it's 2016 regulations. Now, you might recall the tiered protection there was for EEA nationals and their family. You know, at the highest end, highest protection, imperative grounds for someone who was here who'd resided in the UK for at least 10 years, and then the lower protection is grounds of public policy and so on. Next slide, please. Now, what has happened, there's the Nationality Asylum Regulations 2019. These are important regulations in that you will see there, it says, the piece I've extracted there, it says that this instrument has been made using the power under Section 8 of the Withdrawal Act in order to address failures of retained EU law to operate effectively, and so on and so forth. Just 2 points about that. Watch the phrase there is used, the general point here is retained EU law. It's a phrase used in quite a number of instruments and so on, and it's a substitute, or it's taken the place of the phrase that used to be used in much legislation, the idea of enforceable EU law. We're looking historically now, we're talking about retained EU law, and you will see that these regulations, important regulations, we're trying to fill the gaps, and you'll see this the way it's written, it's trying to fill the gaps, trying to catch all provisions sometimes, so that the expanse of EU law, that it will be closed down so that everybody will be catered for under this new regime. Next slide, please. And it says the same there. It's just, that's the explanatory memorandum, which is good to look at when you're reading these regulations. I won't dwell anymore in 11.2. Next slide, please. Now, Regulation 43 of the exit regulations, that's the 2019 regulations. You must, don't forget to recall, in these, you've seen these regulations, there's a lot of primary and secondary legislation amended, disapplied, and so on. And I'm just focusing on the deport issue, and Regulation 43 is an important provision. You will see it says there, decisions taken on conducive grounds. There's a new 27A put in the regulations. An EEA decision may be taken on the ground that the decision is conducive to the public good. Now, that is very broad, and some of you will realize it's a throwback, or it reflects, or to a degree mirrors what is said in the 1971 Act, sections 3 and 5, where slightly different. The Secretary of State has a power because of section 3.1 to deem somebody's removal to be for the public good. And then section 5 in the 71 Act, Secretary of State can deport somebody who has been deemed to get rid of him is in the public good. Now, it's not a this word is slightly different in that it's not said here who the Secretary of State deems is conducive to the public good. That may lead to some scope when it comes to an appeal, that to argue maybe it's not conducive to the public good, but that has problems. But it's just something to look at section 27A or regulation 27A and the old section 3 of the 71 Act. Importantly, subsection 2 of the regulation, decision may be only taken to this regulation to a person as a result of conduct that took place on or after the time this regulation comes into force. I will, when I come to appeals, point out that how broad this provision is, and how not everyone can have an appeal against it, is my reading of the appeal provisions against this decision. I thought first when I was reading this, that this decision perhaps or this provision could be used to try and deport people who are rough sleeping and so on. Because deportation, it's only quite recently, deportation has been so closely linked to criminality. Because indeed, up to about 20 years ago, you could be deported for overstaying. Deportation hasn't the same linkage at all. It hadn't the same linkage to actual criminality that it got obtained under the UK Borders Act 2007. So is this a throwback to that? Is very broad, conducive to public good. Well, you can see how broad that can be. The only qualification I would say that I'm thinking about it is these regulations would have to be interpreted and applied in light of the withdrawal agreement. And it may well be arguable that to remove rough sleepers and so on would be contrary to Article 20 and so on of the withdrawal agreement. But just perhaps it's something worth keeping an eye on, as I'm trying to keep an eye on my time. Next slide, please. Do you mind skipping again to the next slide again? That's it. I'll go on to the appeals now. I've linked there under the appeals regulations. I've listed there possible appeals that are being introduced. The well, I don't say interesting, but the relevant one for this conversation is the one under Regulation 6, an appeal against a deportation order. So now you have the new power to deport a EEA national, and here it is an appeal against it. Is there. What I would say, when you read the regulations, look at Regulation 6.2. I haven't produced it, but look at Regulation 6.2. And my reading of it is that the scope for the personal scope of the appeal is quite limited. Not everybody against whom a deportation order is made will be able to appeal. You will have to have regular status. I'm using that very loosely, regular status. In the UK. So the person in prison, for example, the prisoner who was imprisoned and didn't apply under the settlement scheme, who hasn't applied, or who hasn't got a residence card, or is not registered, who hasn't got leave, it seems to me will not have a right of appeal. And there's real problems that there are groups of people, I think, who will not have applied for pre-settled status or settled status or otherwise have obtained leave, will not be able to appeal a deportation order because of Regulation 6.2. But perhaps you'll have a different view when you read Regulation 6.2. You won't be as pessimistic as I am about it. Could you move to the next next slide, please? There's grounds of appeal there, very broad grounds of appeal with the helpful any matter relevant to the substance of the decision, including any matter relevant to the substance of the decision arising after the appeal. So, and you can appeal grounds of appeal, section 120 statement. And I should have added there, you can also appeal on the ground that the decision is not in accordance with the withdrawal agreement. And the withdrawal agreement, both in spirit and fact, it does confer certain benefits to EEA nationals, tries to prolong the benefits of EEA nationals during these transition times. So it is important. I just noticed the power to remove an appellant while an appeal is pending is retained or is introduced, as is the power that an appellant is to be admitted on bail for the purpose of presenting an appeal. Okay, can I just go 3 slides back to suitability? Is that possible, please? There you are. I just have a minute left. The suitability provisions in the section part 9 of the rules, they apply to non-EEA nationals. Now, something similar is brought in in Appendix EU 15 and EU 16. And that's where we look for the mandatory grounds of refusal and discretionary grounds of refusal in response to an application from an EEA national or family member. My time is up. Thank you.
Thanks, John. Hopefully you can all see and hear me. There's been a lot of acts and regulations to do with the EU movement. I think what happens with this, it can lead to a fair degree of confusion. And I thought for my presentation, what might be useful is if we go back to basics a little bit and talk about what the situation is for EU nationals currently here and EU nationals who are intending to come to the Europe to the UK later on. So perhaps we can start with what we know next. So we know that exit day was the 31st of January 2020, and that was under the European Union Withdrawal Act of 2018. And on this date, the Immigration Citizen Rights Appeal EU exit regulations came into force. And the relevance of that really is that after that date, exit date, those who are refused under the EUSS settlement scheme have a right of appeal. Those who were refused before that date don't. And that's relevant, obviously, when you're advising people of their appeal rights. The end of the transition period, known in the regulations as the IP completion day, is, of course, the 31st of December of this year at 11 p.m. Next thing. And on this date, a number of important pieces of EU regulation come into force. That is the Immigration and Social Security Coordination EU Withdrawal Act, the Citizens Application Deadline and Temporary Protection EU Exit Regulations come into force. And I'll move on to that in a minute. And another term that's also been added to the glossary of EU terms is the application deadline. And you're probably all aware that currently, as it stands, that the EU settlement scheme application deadline is the 30th of June 2021. Next slide, please. Next slide. Yeah. So the Immigration and Social Security Coordination EU Withdrawal Act 2020. So Section 1 ends the right to free movement and revokes the EEA regulations 2016, which obviously is the foundation of the legal rights in existence for free movement. And EEA nationals will be treated as exactly the same as non-EEA nationals and subject to the points-based system and the rules. And EEA nationals per se will not be able to take advantage of that right of free movement under the grace period, and I'll go into what the grace period means. However, family members and those with derivative rights from EEA nationals may be exercised in relation to EEA nationals who had the right of residence under the EEA regulations until the end of the grace period. The Citizens' Rights Application Deadline and Temporary Protection EU Exit Regulations 2020 brings into force this concept of a grace period. And the grace period is the period immediately after the IP completion day, which is the 31st of December 2020, and ending with the application deadline under the EU settlement scheme, which is the 30th of June 2021. As things now stand, after the application deadline date, the 30th of June 2021, EU nationals will not be able to apply for settlement or pre-settlement under the EU settlement scheme. So that is a stop in the legislation, a hard stop in the legislation as things now stand. However, even under the grace period, the provisions of the EEA regulations 2016 specified in those regulations will continue to have effect. Regulation 6 of these application deadline and temporary protection regulations retain with modifications, and it's worth looking at those modifications because they do bring into conformity those regulations with ECJ cases relating to relevant family members and those with Zambrano carers and so on, as well as other categories of those with derivative rights. Next slide, please. So, settlement and pre-settlement under the EU settlement scheme is akin to indefinite leave and limited leave under Appendix EU of the immigration rules. Whilst an application is made for settlement or pre-settlement under the EU settlement scheme before the 30th of June 2021, a decision may not be made until after the grace period has expired. And therefore, with your clients, those who are lawfully resident under the EEA regulations 2016 before the end of the IP completion date, that is the 31st of December 2020, would therefore be protected, have a protected right, and benefit from the equivalent of 3C leave after the end of the grace period has expired on the 30th of June 2021. Those who do not have a protected right in the regulations before the IP completion date, that is the 31st of December 2020, will not therefore benefit from the equivalent of 3C, even if an application is made under the EU settlement scheme. This may create potential problems with work, rent, and benefits, and so on. Next slide, please. So going forward, those who already have settled or pre-settled status will be lawfully in the United Kingdom after the 31st of December 2020, that we know. Those who have residence or derivative rights before the 31st of December 2020 will have a 6-month grace period until the 30th of June 2021 to make an application for settlement or pre-settlement. Those who had a residence or family or derivative rights before the 31st of December 2020 and have a pending application or appeal at the 30th of June 2021 will continue to have leave until that application is finally decided. Those who do not have residence, family, or derivative rights before the 31st of December 2020 and have a pending application or appeal on the 30th of June 2021, in my understanding, will be unlawfully resident after that date. As I say, the regulations brought in an appeal from the end of January 2020 for EEA nationals, family members, and derivatives. So that is, as I understand it, the transition arrangements. Obviously, this is a moving target to a certain extent, and one will have to see what happens after the 30th or before the 30th of June 2021 to see whether that is extended on any level. But as it now stands, I think it's important that those dates are advised to people, because I think that there is a real chance that there'll be categories of people who are simply not aware of their rights and may create a windrush type of situation where people do actually have the right to settle status or pre-settle status under the EU settlement scheme, but simply are not aware of when or how to apply. And I think it's important that these basic dates and rights need to be advised to clients. Thank you.
Whilst you're finding that, Simon, I wondered whether we could just go back to John. I know there's a question in the Q&A that was for him. Should we just do that quickly and then come back to you?
Yeah.
So, John, the question for you from Svetlina Efti talks about biometric residence permits ceasing to be valid for EEA nationals and their family members. So people who thought they would have had, particularly family members, a resident permit valid until, I don't know, 2025, which of course won't be anymore, and the failure to advise those people properly. And she's talking about an extension to the hostile environment. Do you have any comments on that? Her full question's in the Q&A.
Yes, I saw it. Thank you. Yeah, just two comments. Firstly, it's good to look at the withdrawal agreement, because there's repeated reference there to procedural safeguards and procedural rights. That may be a source for an argument that the scheme or the approach of the Home Office is not adequate and is contrary to the withdrawal agreement. Secondly, the problem is, of course, that once we have left and comes at the end of the transition, indeed the grace period, residence cards or the like anyhow lose their efficacy, because the foundations on which they were based has fallen away. So I think there would be room, of course, depending on how well a case is put, that in an individual case or in groups of people, the notifications weren't adequate. I know the latest figures, I think, for the settlement scheme was about 4 million or just over 4 million. And I know one of the universities did some research and found a lot of people are not aware and have not been aware. Certainly that will give rise to litigation, I think, because what will happen, people will be picked up, or they'll be they'll find themselves here without any proper leave. And yes, I think you say it's a hostile environment thing as part of that. Well, perhaps so, but I'm thinking down the road it's going to become a big issue, this. Yes.
Thanks, John. Simon, how are we doing? I think you're on mute.
We are fine now, according to Ray. So Ray, could you share the slides again, the ones that I just sent? My apologies, everybody. Great. Could you click on one? Thank you. So very crudely, I think the basic message that will be coming from the top is that people arriving who are EEA citizens, family members, will fall into one of these two groups. They've either already got an EUSS document of some kind, or an EUSS status, because it's an electronic status, or they fall under the immigration rules. Now, of course, their training hopefully will be that it isn't that simple, and it'll look more like this. Next slide, please. So we're going to try and tease out that group of people in the second, on the right-hand side of your screen as you're looking at it. And I'm going to break the groups down into 5 different groups. Next slide, please. So we've got people who've got EUSS status. I'll explain what that means in a second. We've then got returning residents. That's people who were already had arrived in the UK before the 31st of December of this year, before 11 p.m. on the 31st of December, which is the date. Then we've got people who've never been to the UK before, but already have family connections in the UK. We've got frontier workers, and we've got everybody else. Next slide. So group 1, these are people who've either already been granted leave under the EUSS scheme, or they've got a family permit issued under the EUSS family permit rules, which is different from the immigration EEA regs, or they have a travel permit. Next, please. And I'll come back in a moment to describe what those are. But before we look at everybody else in the middle, let's look at who the out group are and how they're treated, because this is what's going to happen to EU citizens who arrive at the border and choose to go through the E-gates in particular. If they walk through the E-gates, and if they're allowed through the E-gates, they're going to be deemed to have entered as a visitor for 6 months with a prohibition on work and no recourse to public funds. We have the regulation there, and we'll share the proper final version of the slides after this call. But attaching conditions to leave doesn't apply to somebody who in John's division isn't subject to immigration control. And as we've heard from Tubli, we know that some people have protection during the grace period. So I want to tease that out and look at those different groups. Next slide, please. So then the first group of people is people who were here already, but don't yet have EUSS status. And as the first question for those people is, were they lawfully resident in the UK on the 31st of December 2020 at 11 o'clock in the evening? And they don't need to have been present in the UK. They only need to have been lawfully resident. So they may not have been here, but still be resident, or they may have been here, but not have been lawfully resident. Next slide. So you can count your residence under the normal rules for acquiring permanent residence for EU status, even during your absence. And so these rules are carried over from the EEA regs. 6 months in any year, 12 months once for an important reason, or for compulsory military service. Now, how exactly they'll play, we don't know. In particular, suppose you, on the 31st of December, you've been away for 5 months, but you don't come back until February, by which time you've been away for 6 months. Does that mean that you weren't here on the 31st of December during a period of lawful residence? We don't know. Next slide, please. The other group of people to bear in mind is people who did acquire permanent residence. If they haven't lost it, then they still count as being resident under the EEA regs. So they will have lost it if they've been continuously absent for 2 years. But even if they've been continuously absent for 2 years, actually, under the special exception there, they need to be continuously absent for 5 years. So you may have people who acquired permanent residence before 2015 and who were living here up until the middle of 2015 and have now been away for 5 years. They still count as being lawfully resident in the UK. Next, please. The lawful residence in the UK only is expressed to count under the EEA regs. But the EEA regs have always lagged behind actual EU law rights of residence. There's a couple that I mentioned there. Sampre rights, people who, women who have had to stop work because of pregnancy or childbirth and haven't gone back to the job market. And John Walsh's case of Carpenter from 20 years ago, under which family members of British citizens who are living in the UK but have some work abroad in the EU can have a right to reside. But they really ought to be covered. And I think if push comes to shove, either the Home Office or the courts will accept that that's how you read the regulations. Next, please. Now, one question that's been raised is what happens to the last minute arrivals? What happens to the person who gets off the flight from Orléans at 10:30 at night on the 31st of December? Now, if we look at residents, we might say, well, they're not really residents, are they? They're only present. But actually, in my view anyway, EU law doesn't draw a distinction here between residents and presence. We see that in the UK's implementation of the Citizens Directive. The right of residence begins on the date of admission. And if we look back at the root of all this in the withdrawal agreement, we see that it's about people who exercise their right to reside. So it's a right to reside, not an actual being resident. So my view is that this ought to be interpreted as meaning that presence is enough. So if you've walked through the E-gate just before 11 o'clock on the last day of the year, or perhaps even if the wheels of your plane have touched down on the tarmac by that time, then you count as covered under the scheme. And remember that for the first 3 months of your presence, you don't need to be working or self-employed. You just need to be here and not have been stigmatized as someone who's relying on public funds. So in fact, people who arrive from the 1st of October are maybe in a much clearer position than people who arrived before that, because they arrived in the 3 months running down to the 31st. Next slide, please. Now, this temporary protection for this group only lasts until the 30th of June, as Tublu has explained. But if they make an application under the EUSS scheme before that date, it will continue. So from the 1st of July of next year, we can expect to see immigration officers checking and saying to people, well, you may have been living here before, but you haven't made an application. Next slide. Now, what about group 3? This is people who've never been in the UK, but they're family members of someone who's in the UK. And there are two distinct groups here. The first group is family members of someone who already has EUSS leave at any time. It can be granted after the 31st of December. Now, those people can apply abroad for the EUSS family permit, and there's no time limit expressed in the rules as to when that they can do that. Next slide, please. Now, who counts as a family member? Well, it's the EU definition, but with some favours. If you're a spouse already on the 31st of December, you count. If you're a durable partner already on the 31st of December, you count, as long as you've got the residence card, but which can be issued after that date. And the key favour is that if you're a dependent parent under the definition in the Appendix EU family permit, then dependence is assumed. So you don't need to prove that your parents or your grandparents or your great-grandparents coming from abroad to join somebody here with EUSS status were in fact dependent on that EU citizen. But you do for children over 21. Next slide, please. Now, what happens if the family member in the UK hasn't got EUSS status yet? What happens if their application is outstanding or they haven't got around to making it? Well, those people can't apply under the immigration rules. Sorry, their family members can't apply under the immigration rules, but they still have a right to enter under the temporary protection regs. If they can show that the principal was lawfully residing here under the EEA regs on the last day of the year, then they also have the right to enter the UK without leave until the 30th of June 2021. How they'll prove that in practice and how they'll arrive here if they are visa nationals are more difficult questions. But as a matter of law, and if they turn up at the port of entry, then they have the right to enter if they can show that they are the family member of somebody who is a temporary protected person here and who hasn't yet got EUSS leave. But if they have got a EUSS leave, then that person will fall under the first set of rules that I've talked about, and may be expected to, or maybe expect to be refused for lack of an entry clearance. Though we will have to see how the Home Office approaches that in practice. Next, please. Then the last group that I want to talk about who still have rights deriving from what was happening before the end of this year is frontier workers. Those who were frontier workers on the 31st of December 2020 at 11 o'clock in the evening keep the right to be frontier workers. The definition of frontier worker, I've set it out on the slide. It's somebody who's working or self-employed in the UK and who was not present in the UK for 180 days in the last 12 months, but returned to their country of residence at least once. So in other words, has an element of coming back and forth, but it isn't in the UK for most of the time. If that person was in the UK for 6 months in the last 12 months, then they would keep their status, even if they weren't here on the 31st of December. And so the frontier worker category is for people who are spending less time in the UK than half of their time. There shouldn't hopefully be a gap in the middle, people who don't count as frontier workers, but whose absence counts as too much, but we'll have to see whether that happens in practice. Next, please. Next slide, please, Ray. Thanks. Frontier workers, a little bit like the family members of temporary protected people, have this right under EU law or under the UK regulations implementing the withdrawal agreement to come to the UK. They don't need to have a document, but of course in practice they're going to have to prove to the immigration officer on entry that they are frontier workers. From the end of the grace period, they will need to hold a frontier worker document. Next, please. Last of all, I just want to mention before my time's up, because for those of you who hear me speak know that I almost always speak about Zambrano cases. I just wanted to recap, since I've got your attention, some things that I think people are still missing out on with Zambrano cases. Very quickly, don't forget the deadline is the same as it is for other cases, the 30th of June, 2021. We're seeing cases where the Home Office is getting the law wrong about the kind of deportation order that disqualifies you under the EUSS scheme. Only deportation orders that would justify deportation on EU law grounds disqualify people under the EUSS scheme. So regular automatic deportation orders made against people because they were considered not to have EU law rights do not affect the right to reside of Zambrano people. And secondly, that we're still seeing the Home Office routinely refusing people on the basis that they could apply for leave to remain. That is not a ground of refusal under the EEA regs or under the EUSS scheme. Only people who actually have leave to remain can be refused under the EUSS scheme, and there is a legal challenge to the lawfulness of that rule. Last slide, please, Ray. And lastly, there's a long-standing issue here that hasn't been litigated in the courts, which is the very clear wording of the two provisions of the EEA regs on shared care, which my view is that they are explicit and that they require that where there are two carers, so for example, a married couple, that they both have the Zambrano right to reside, unless the children could remain in the UK if they both left the UK. And since 2018, that has applied to couples where one member is a British citizen or has indefinite leave to remain, thanks to an extension of the regulation in 2018. The Home Office like to pretend that it doesn't say what it says, and they will cite cases to you like Patel and VM Jamaica, which say that these people don't have a right under EU law, but it's what the regulation says. And there's nothing that requires a regulation which gives more rights than EU law to be read down by EU law. EU law is only there to give people rights. It's not there to take those rights away that the Secretary of State has deliberately given by express words of regulations. So I'll stop there and allow the rest of the time for questions.
Thank you so much. So yeah, we have a couple of questions. There's one that came in by email beforehand. So maybe Simon, I'll ask that to you first, because it concerns something you touched upon, which is dependent parents or dependent family members, or actually non-dependent in this case. And she asks, she understands that a non-dependent parent can come into the UK before the end of June 2021 and then be confident they'll get settled status within 5 years. And she has a slight worry because she's attended another seminar where there was caution voiced about assuming a person will not need to show dependency within that 5-year period prior to settlement. So she wanted to check her understanding of that.
Well, we don't know whether or not the Home Office will amend the immigration rules, but the current immigration rule definition in Appendix EU and in Appendix EU family permit says that for dependent relatives in the ascending line, so that's grandparents, great-grandparents, of the EU citizen and their spouse, whatever the spouse's citizenship, that dependency is assumed. And I think we can assume that that is a result of a deal that's been reached with the Commission, and that therefore the UK would be reluctant to amend those rules to take it away. So it seems to me that as long as that rule stays in place, that's the requirement that needs to be met in order to have, in order to acquire settlement at the end of that period. Rowena, do you want me to answer the other question about people who arrive here as family members?
Yeah, that'd be great. So that's a question from Eva.
So Eva asks, what happens to people who come in after the 1st of January as a visitor and then want to apply on the basis that they're a family member of somebody in the UK who has leave under the EUSS scheme? Well, as long as they meet that definition of family member, that is that they were already a family member before the end of the year, unless they're a child who's born or adopted after that date, then they qualify under the EUSS rules and they can apply. And so they ought to be granted that leave to remain in the UK, just as if they had already been here before the 31st of December. That's my view.
I think the question, Simon, is if they came as a visitor would mean they came after the 30th of June. So
after the 30th of June.
I think so. Otherwise, it wouldn't be a visitor.
Well, no, they would if they came. Yeah, no, they would be a visitor if they came on the 2nd of January. They might just enter, not realise that they need to go through a different route. So somebody just, I mean, a French citizen just arriving here in March will walk through the gates and then can apply. So I mean, I think that's an important, and that gives an important pointer actually, that it's really only third country nationals who are visa nationals who will have a particular problem with reaching the UK. But one must be also careful, I think, about issues of representation. So if people are representing that they're coming on a visit, when in fact they're coming to be reunited with their French or German or Italian children, then there might possibly be questions down the line. But certainly if somebody finds themselves here, then there is no requirement that I can see in the rules that they have to leave again and apply from abroad.
There's another question here in the chat from Nigel. Actually, Nigel's asked two questions, Nigel Leskin. The question in the Q&A is relating to somebody who has pre-settled status and has been in a durable partnership for a period of under 2 years currently, and won't have clocked up 2 years by June. And he's asking, if they get married before June 2021, can they then apply, or does he need to be married before the 31st of December? Anyone got any views on that?
You've got to be married before the 31st of December. Either you've got to be a family member under the EU definition. So you've either got to be married, or you've got to have done your 2 years as a durable partner before the 31st of December. The application deadline is extended, but you will need to have met the facts at the 31st of December.
And Nigel also asks in the chat why there's no reference to the 30th of June in the Appendix EU, why there's only 31st of December 2020 in Appendix EU. That may not be a question that we can answer.
Nigel, I think the reason is because the rules are the criteria for granting leave to remain. And what the temporary protection regs do is they extend the rights to reside of certain categories of people. So the temporary protection regs are not the rules that you need to meet to get leave to remain. They're about the status that people have after the 31st of December if they haven't got that leave to remain. And so the 30th of June is the date, that the deadline for the application and for this extended status. It's not about whether or not you meet the requirements of the rules.
There's a question here from someone called Sedef. I don't know if you can see that in the Q&A. The question is, he's got a client, or she's got a client who has applied as a non-EU national family member of an EEA national. That individual has a pending appeal. What will happen in respect of the rules? The question asks. So what will happen?
Is it a deport appeal or an appeal for a permit?
That's unclear. I think it would be an appeal for a permit from the looks of things.
Yeah. So I posted in the chat. Sorry, I posted in the Q&A an answer to somebody else's question, which and if you look, it's an answer to Omar Hussein's question at 3:22 p.m. The Immigration and Social Security Coordination's EU Withdrawal Act 2020, Consequential Saving, Transition and Transitory Provisions, regs, cover these matters. And if you look at Schedule 3, you'll see that that continues the existing rules as they apply to current appeals. So the regulations and acts go on applying in the same way to the process of the appeal. However, those same regs do not protect all the kinds of documentary rights, but they do protect the right to be issued with a family permit, it seems. So my understanding of the policy is that they will go on issuing family permits on applications made before the 31st of December, but they won't go on issuing other forms of documentation. I'm still not clear about how this plays with durable partners who need to obtain a residence card. I don't know the answer to that.
There's another question here in the chat about naturalisation. It's a question from Theo Stanmos. If the panelists can see that, I'll just read it out. Wouldn't EU national be able to apply for naturalisation as a British citizen between 1st of January 2021 and 30th of June 2021 if they are in possession of a document certifying permanent residence in the UK, showing they acquired permanent residence in 2017, obviously under the EEA regs, haven't registered under the EUSS, and have been continuously employed in the UK since 2012? Would applying for under the EU settlement scheme supersede permanent residence and require a 12-month wait? So in essence, that's someone who has permanent residence currently and wants to apply to naturalise, but hasn't yet applied under this EU settled status scheme, and has shown that they've also been. I mean, this relates to one of the problems with naturalisation after acquiring settled status. I mean, in that case, it's not because this individual had permanent residence, but there are lots of people who I think will struggle, having had EU settlement, having achieved, having acquired settled status, to then go on to naturalise a year afterwards, given that they then have to prove that they were here either working or otherwise exercising a treaty right. Anyone else got any views on the on that case? Okay, let's move on. There's another question here. I think actually you might have already answered this, but it's a Keane's question in the chat. If you start your relationship before the 31st and already applied and get married in January, does that cover you? I assume not, given that you need to be married before the 31st of December, is what you've already said.
That's right. There's no, the regulations and law doesn't provide any. You gave your notice before the 31st, or you had your bans announced or anything like that. You've got to be a family member by the 31st.
Catherine Denyer says she thinks that HC 813 will stop joining family members from switching into EUSS if they arrive after IP completion dates.
I'd need to think, Catherine, about which provision it is you think there that stops people switching into EUSS. I'm not sure. I'm sorry, I don't know off the top of my head which bit you mean. But happy to try to deal with it if we can resolve it in the next few minutes. But I mean, my reading of the I haven't seen an obstacle in the rules, but I'm happy to try and deal with it. Oh.
There's not a question, but an FYI from.
It's in your next quote, Catherine. I'll look at it and come back. Sorry,
just before you come back to that, just another a point actually from Lawrence Yusefian. Talking about the argument about the wording of the EEA regs in Zambrano, where primary care is shared by two parents. He says that's being heard in the upper tribunal, he's told this week, under the case name is AV Kosovo.
Right, okay, thank you.
Did you want to come back on Catherine Denyer's point, Simon, or should we?
That's the only thing. I'm looking at what you quoted in the chat, and I don't think that. I mean, that my understanding of that rule, 14A, is that's not the relevant rule for the EUSS rules. But we may be talking at cross purposes. I'm just trying to find that rule. So wherever it's got to. Yeah, the EUSS scheme is a largely a self-contained scheme, and so Sorry, I'm so sorry. I'm looking at the wrong rule. It's the problem of trying to do advice on the hoof at the end of a seminar.
Whilst you're thinking about that, Simon, let me ask another question.
Yeah, you're right, Catherine. That is a problem. You're absolutely right. EU 14A is a problem. So I think if people have entered as a visitor through the gates, that would pose a problem. That's very helpful, and it shows one of the risks of trying to answer this stuff live in a seminar at the end of a seminar. So people can see Catherine's note there of 14A.
So yeah, just another question, a clarification from another question from Eva. Can I just check, do EEA documents become obsolete on the 31st of December 2020 or 30th of June 2021?
Neither. I mean, the point is that the Home Office would say that the documents don't prove anything anyway, I'm afraid. If they're permanent residence documents, then they're still useful for applying for EU settled status. If they are other forms of residence cards and documents, then they're not going to help. They're not themselves documents that entitle you to re-enter the UK. You're going to have to show that you meet the rules that I was talking about. In other words, that you were lawfully resident in the UK on the 31st, or that you are the family member of somebody who was lawfully resident in the UK on the 31st.
So I think we haven't got any time for any more questions. We need to finish this on the dot at 4. Can I thank all our speakers very much, and thank you all for joining us. And just before we leave today's seminar, just to plug what we have got coming up in January. So we'll be back bright and early in January with a year in review seminar, looking at the roundup of case law in 2020, this rather exceptional year, and also what's to come in 2021. Looking further ahead, we've got lots of exciting seminars, one on the future of Dublin, one looking at Court of Appeal cases on deportation, where there's been some recent interesting developments, and also celebrating the 70th anniversary of the Refugee Convention and an event around the 10th anniversary of the Equality Act. So we very much look forward to seeing you in the new year. And in the meanwhile, we wish you the very best compliments of the season. Thank you.